Sir, good evening.
Good evening. Good evening.
5 minutes ಇದೆ sir.
Okay.
Six o'clock. Can we start the program, sir?
Yes, sir.
Very warm good evening to one and all. Advocates Association Bengaluru, in collaboration with Advocates Academy Bengaluru, is hosting the first of webinar series 2025. In this regard, we have had couple of webinars, and today's topic chosen is Commercial Codes Act 2015. We have a very special resource person with us today. Sir needs no introduction. Sir, on behalf of Advocates Association Bengaluru, Advocates Academy Bengaluru, and on my personal behalf, sir, I extend a very warm welcome to you. Over to you, sir.
Thank you, Mr. Vikas. Thank you, Mr. Vikram, and thank you all the participants. Uh, I think this is the third presentation I am making successively, 5th, 12th, and 19th. Now, the Commercial Courts Act has two parts. One, starting from section 1 and ending with section 23, the Act as such. Then there is a schedule to the Act which contains the provisions of Civil Procedure Code as amended by the Commercial Courts Act. Several provisions of the Civil Procedure Code have been amended by the Commercial Courts Act, and those amended provisions are applicable only to the working of the commercial courts. Time would be insufficient to deal with both the sections and the schedule. It takes a good lot of time. Secondly, for the participants to correctly understand those amendments, it is necessary for them to have with them the code of civil procedure also. Otherwise, it will be difficult to follow what actually the amendment brought by the Commercial Courts Act for certain provisions in the Civil Procedure Code. Therefore, we will take it as parts 1 and 2. Part 1 only today we are dealing with, that is the Act portion of the Commercial Courts Act. There is no need to read all the sections, only those sections which are of practical utility to the lawyers appearing in the commercial courts and in the civil courts also. One thing I want to make it clear, it is not as if the Commercial Courts Act is relevant only to those lawyers who have chosen their work in the commercial litigation and who regularly appear in the commercial courts. Even lawyers who appear in the civil courts, it could be the city civil court or the rural court or elsewhere also, a knowledge of the Commercial Courts Act is required. Now, appearing for the plaintiff, you file a suit in the regular civil court. The defendant states that the dispute is a commercial dispute, and therefore either the matter should be transferred to the commercial court or the plaintiff should be returned. Now, appearing for the plaintiff, you should know whether it is a commercial dispute at all. Secondly, whether all commercial disputes need to be transferred to the commercial court or the plaintiff should be returned for representation to the commercial court. Therefore, certain definitions of the Commercial Courts Act would assume importance, and it is in this context I am of the opinion that this knowledge of this act is not just relevant only to the lawyers practiced in the commercial courts, it is necessary for those practiced in the civil courts also. Now, the reason behind enacting this act is only this. Now, the statement of objects and reasons would indicate that India is a growing economy. Foreigners are intending to make investment in India. Therefore, if commercial litigations take a long time, they would be dissuaded from making such investments in India. Therefore, the Parliament thought it fit to enact a special law called the Commercial Courts Act with certain timelines. This is the main object. So, it is the duty of the judiciary and the bar to see that the object of the enactment is not frustrated. We cannot take the litigation in the commercial courts as a regular civil litigation, and we will have to see that the disputes come to an end expeditiously. Let us have a look at the long title to the enactment. An act to provide for the constitution of commercial courts. Then commercial appellate courts, commercial division, and commercial appellate division. So 4 things: commercial courts, commercial appellate courts, commercial division, and commercial appellate division in the high courts for adjudicating commercial disputes of specified value. This is important. It is not all commercial disputes which are triable by the commercial court. It should be a commercial dispute as defined in section 2C. It should be of a specified value as defined in section 2I and as determined under section 12. Let us be very clear. It should be a commercial dispute falling under any of the categories. About 22 categories of disputes have been shown as commercial disputes in section 2C. So the dispute should be a commercial dispute as defined in section 2C. The specified value is defined in section 2I and how it is determined is stated in section 12. These twin conditions should be satisfied for the commercial court to entertain a matter. So we can't just presume some transaction is going on, it's a commercial dispute. It is not in that sense. Whether that transaction qualifies itself as a commercial dispute as stated in section 2C. Now, when it comes to the specified value, it is not valuation for purpose of pecuniary jurisdiction or valuation for purpose of court fee under the Court Fees and Suits Valuation Act. Let us not import our knowledge to the Karnataka Court Fees and Suits Valuation Act in determining specified value because section 12 says what the specified value is. Now, all definitions may not be very important, but let us just concentrate on definitions which are some important. 2(1)(a), commercial appellate courts means the commercial appellate courts designated under section 3 capital A. Commercial appellate division means the commercial appellate division in a high court constituted under subsection 1 of 5. B. Commercial court means the commercial court constituted under subsection 1 of section 3. And you may also notice that the Act has come into force on 23/10/2015. Commercial Code Section 2B, the Commercial Code constituted under subsection 1 of Section 3. Let us see what it is. Section 3, subsection 1. The state government may, after consultation with the concerned High Court, by notification constitute such number of commercial courts at district level as it may deem necessary for the purpose of exercising the jurisdiction and powers conferred on those courts under the Act. I will read it again. The state government may, after consultation with the concerned High Court, constitute such number of commercial courts at the district level. It does not mean that the commercial court should necessarily be a court of the cadre of district judge. The government may think of constituting a civil judge as a commercial court, a court of a civil judge, a court of a senior civil judge. Of course, presently in the state of Karnataka, it is the courts presided over by the cadre of district judges who are constituted as commercial courts for good reason. But there is nothing in this act which gives an indication that it is only a court presided over by a judicial officer, the cadre of district judge, should be a commercial court. Courts at the district level, as it may deem necessary, then we can avoid this proviso because certain high courts in the country have original jurisdiction. We will leave it. Then it also provides for commercial appellate divisions and all that. Now, straight away, let us go to section 6. Jurisdiction of the commercial court. That's important for us. The commercial court shall have jurisdiction to try all suits and applications relating to a commercial dispute of a specified value arising out of the entire territory of the state over which it has been vested territorial jurisdiction. So what is the jurisdiction of a commercial court? To try all suits and applications. What those applications are, I will tell a little later. Relating to a commercial dispute. It is not that every suit can be tried by a commercial court. It is not that every commercial dispute can be tried by a commercial court. A commercial dispute of a specified value. What is that commercial dispute? It doesn't involve any common sense. It has been defined. So we should strictly go by the definition. Maybe some subclasses of section 2C call for an interpretation. That depends upon how the courts have taken you. I will give you a few decisions. Maybe certain categories of disputes may, in the opinion of one court, be a commercial dispute, may not be so. Ultimately, it's for the Honorable Supreme Court or the concerned High Court to finally pronounce upon those things. Then, the explanation for the purposes of this section, a commercial dispute shall be considered to arise out of the entire territory of the state over which a commercial court has been vested jurisdiction. If the suit or application to such commercial dispute has been instituted as per the provisions of section 16 to 20. Now, here itself, it is necessary for us to refer to section 10 also. Section 7 avoiding jurisdiction of commercial divisions of high courts. My focus is on young advocates practicing in the trial courts. Therefore, I am just leaving it. We'll straight away go to section 10. Jurisdiction in respect of arbitration matters. Where the subject matter of an arbitration is a commercial dispute of a specified value. Please mark those words. It is not all arbitration cases get transferred to the commercial court, or the plaint should be returned, or the application should be returned. No. The subject matter of the arbitration should be a commercial dispute of a specified value. It is not every arbitration case automatically gets transferred. It's a different matter that in most of these arbitration cases, the dispute is of a commercial nature as defined in section 2C. But there could be a matter which is the subject of an arbitration agreement, but yet it may not be a commercial dispute. For example, there is a lease agreement. In the lease agreement, there is a provision for referring the matter to arbitration if there is a dispute between the lessor and the lessee. But the demised premises is a non-residential one or a house premises. It cannot be a commercial dispute. It cannot be a commercial dispute. So therefore, we'll have to take into consideration. Here again, there is one more thing. Of course, it's slightly incidental. Merely because there is an arbitration clause, maybe eviction disputes cannot be referred to arbitration if the premises is covered by the provisions of the Karnataka Rent Act. It's a different matter, but just keep that also in view. Therefore, merely because there is an arbitration agreement, automatically the matter cannot be transferred to the commercial court. So it should be, the arbitration dispute should be a commercial dispute, and if it is of a specified value. For those practicing the trial courts, section 10, subsection 3 would be material, and I will read it. If such arbitration is other than an international commercial arbitration, all applications, section 9, 34, 36, execution, or appeals arising out of such arbitration under the provisions of the Arbitration and Conciliation Act that would ordinarily lie before any principal civil court of original jurisdiction in a district, because under the Arbitration and Conciliation Act, these petitions under 934, they would lie before the principal civil court of original jurisdiction. Incidentally, I may also tell you that the principal civil court of original jurisdiction does not mean the principal district judge, because under the Karnataka Civil Courts Act, all district judges are principal civil courts of original jurisdiction, shall be filed in and heard and disposed of by the commercial court exercising territorial jurisdiction over such arbitration where such commercial court has been constituted. Therefore, an arbitration proceeding also gets transferred to a commercial court, or the application may have to be returned for presentation to the commercial court if it is a commercial dispute of a specified value. Now, One other thing needs to be noticed here itself, that is section 11. Notwithstanding anything contained in this act, a commercial court or a commercial division shall not entertain or decide any suit, application, or proceedings relating to any commercial dispute in respect of which the jurisdiction of the civil court is either expressly or impliedly barred under any other law for the time being in force. It is a sheer coincidence that I am speaking to you about the Commercial Courts Act just a week after I spoke about Section 9 CPC, jurisdiction of civil courts. Now, I said that the jurisdiction of a civil court is all uh, comprehensive, all encompassing, unless the jurisdiction is impliedly barred by any statute or expressly barred, or the provisions of CPC themselves bar the jurisdiction. Supposing Section 9 bars a suit, either there is an implied bar or express bar created by a special enactment, or certain provisions of CPC have drawn your attention extensively to the provisions of CPC which bar a suit. Order 9, Order 23, have Order 11, Rule 21, number of such provisions have drawn the attention of the audience. So if the civil court cannot entertain that, then the commercial court also cannot entertain that. That also can be kept in view. Now, before we take up what this commercial dispute and specified value is, because it requires some discussion, let me go to section 50, transfer of pending cases. Subsection 1. All suits and applications, including applications under the Arbitration and Conciliation Act, relating to a commercial dispute of a specified value. Almost every provision in the Act says commercial dispute of a specified value. We have a judgment of the Karnataka High Court which says the twin factors that need to be satisfied for the commercial court to entertain, or it should be a commercial dispute and it should be of a specified value. Decisions I will give it at the end. Subsection 2. All suits and applications, including applications under the Arbitration and Conciliation Act, relating to a commercial dispute of a specified value, pending in any civil court, in any district or area, in respect of which a commercial court in any district or area, in respect of which a commercial court has been constituted, shall be transferred to such commercial court. We'll have to read this subsection very carefully. All suits and applications, including applications under the Arbitration and Conciliation Act. Section 9, 34, execution proceedings under 36, Order 21, relating to a commercial dispute of a specified value, pending in any civil court. Let us say, in a regular civil court, a suit is pending. It is in respect of a commercial dispute of a specified value. It's a pending suit. Today, there is no commercial court for that area. Tomorrow, a commercial court is established for that area where the civil suit is pending. What is the effect of subsection 2? That suit, which is pending today, by virtue of the establishment of a commercial court with effect from tomorrow, that suit needs to be transferred to the commercial court. But today itself, there is a commercial court in existence for a particular area. Today, ignoring the existence of a commercial court or not knowing that it is a commercial dispute or some doubt as to the specified value or deliberately, a suit is filed in the regular civil court. That cannot be transferred. Plaint has to be returned under Order 7, Rule 10. Let us just have a look at Order 7, Rule 10, only to refresh our memory. return of plaint. Subject to the provisions of Rule 10A, I am avoiding Rule 10A because it's not the scope of discussion today. The plaint shall, at any stage of the suit, be returned to be presented to the court in which the suit should have been instituted. Normally, in our regular practice, the 7 Rule 10 is invoked when there is no pecuniary jurisdiction, and territorial jurisdiction, if they are reading from the plaint itself, indicates that there is no territorial jurisdiction. But there is nothing in Rule 10 to confine its operation only to territorial and pecuniary jurisdiction. If the court otherwise also does not have jurisdiction, what is the consequence? Now, one such thing is this commercial court. So, if a suit is already pending, if a suit was instituted before the establishment of the commercial court, that needs to be transferred after the establishment of the commercial court for that area. But after the establishment of the commercial court for that particular area, if the suit is instituted in the regular civil court for whatever reason it be, as I said, deliberately or being ignorant of the establishment, not knowing the specified value, some are not able to understand whether it's a commercial dispute or not, then that cannot be transferred. The plaint needs to be returned for presentation to the commercial court. This is another aspect of the matter which we need to bear in mind. Now, the next thing is, what is this commercial dispute? The other definitions are not very important. Important definitions are commercial dispute and specified value. Section 2C, 21C. Commercial dispute means, does not means and includes, means an exhaustive definition. A dispute arising out of 22 categories are, rather 21 specified categories are given. Subclass 22 says such other commercial disputes has to be notified by the central government. So we'll have to keep a track of those notifications as and when the central government notifies saying that this also shall be a commercial dispute, that also becomes a commercial dispute under section 21C. So 21 categories of suits are mentioned. It will be a very laborious thing for me to read and for those to listen to also if I start reading what these 21 disputes are. As and when an occasion arises, find out whether the dispute which your client has brought to you falls under any of these clauses of 1 to 21. I am referring only to a few important commercial disputes which might arise in the usual course. 2C1. Ordinary transactions of merchants, bankers, financiers, and traders, such as those relating to mercantile documents, including enforcement and interpretation of such documents. In fact, this provision itself calls for an interpretation. One view is that every suit instituted by a bank or a merchant or a financier gets transferred to the commercial court, or such a suit has to be instituted in the commercial court. Another view with which I also share, it is not that all suits filed by banks need to be transferred. There are decisions for either proposition. Ultimately, it is for the Honorable Supreme Court to take the view. I will tell what those decisions are. Why, according to me, all suits filed by banks do not qualify themselves to be commercial disputes. Export or import, issues relating to admiralty, issues relating to aircraft, carriage of goods, construction and infrastructure contracts, including tenders. This will be of some relevance. 7. Agreements relating to immobile property used exclusively in trade and commerce. The property should be exclusively used in trade or commerce. I began telling that there is a lease agreement, obviously in respect of an immobile property. Now, Merely because it is an immovable property, there is an agreement, it cannot get transferred to the commercial court, or the suit need not be filed in the commercial court. That immovable property, the demised premises, should be used exclusively in trade or commerce. Otherwise not. If it is given for residential purpose or for running a hostel or something of that kind, I don't think it cannot be the subject matter of a commercial court does not get used. That demised premises, the immovable property which has been let out, it is the subject matter of the lease, should be used exclusively in trade or commerce. Both those conditions exclusively. A portion of it, maybe the tenant is running business in another portion, he resides. If that lease cannot be split up, then agreements relating to immovable property used for franchising agreements, distribution and licensing, management and consultancy, joint venture agreements, these JDS and other things, shareholder agreements, etc. Now, with regard to this joint development agreement, also I have got something to say. You see, in a suit for partition, if there is already an alienation, either by the manager of the joint family or any of the co-partners, then usually there will be a prayer that the alienation does not bind the plaintiff co-partners. If it is by a co-partner who is not the manager, that would be the prayer. If it is an alienation by the manager or the father, the government in the plaintiff, it was not for legal necessity or benefit of estate, and therefore the sale is of no consequence. Now, supposing either the manager or any of the co-partners or even a co-sharer has entered into a joint development agreement with an outsider that is not a member of the family, merely because there is some reference in the plain to the joint development agreement, or there is a prayer saying that the joint development agreement entered into by the second defendant with sixth defendant does not bind the plaintiff's share, that is not a suit which needs to be transferred to the commercial court. It is only an incidental prayer that is made. The main dispute is partition, whether the parties are co-sharers, whether the properties are joint, whether the relationship is there. These are the issues that would arise. This is only an incidental thing. Therefore, merely because there is a joint development agreement or some GPA followed by joint development agreement, preceded by joint development agreement, memorandum of understanding and all that, please take care to see that such suits do not lie in the commercial courts, or the defendant says that those suits need to be transferred to the commercial court, or the court takes such a view. You should be able to tell them that it's only an incidental prayer and it cannot be transferred or trade cannot be returned. Shareholder agreements, mercantile usage, technology development, intellectual property rights relating to registered and unregistered trademarks, so IPR matters, copyright, they all qualify themselves to be called commercial disputes. Agreements for sale of goods or provision of services, exploitation of oil and gas reserves, insurance and reinsurance, contracts of agency relating to any of the above, that is, all these, such other commercial disputes. Now, explanation also needs to be noticed. A commercial dispute shall not cease to be a commercial dispute merely because it involves action for recovery of immovable property or for realization of monies out of immovable property given as security, or involves any other relief pertaining to immovable property. So therefore, it is that if the premises is let out exclusively for trade or commerce, well, a suit for eviction, then recovery of rent, all those things. Then, so of course, I'll come to the decisions later. Now let us go to the definition of the word specified value, section 2I. Specified value in relation to a commercial dispute shall mean the value of the subject matter in respect of the suit as determined in accordance with section 12. Therefore, we'll have to read section 12 also to know what actually specified value is. But something more is important, which shall not be less than 3 lakhs rupees or such higher value as to be notified by the central government. So this 3 lakhs, it's an amendment brought with effect from 3/5/2018 by Act number 28 of 2018. Earlier it was 1 crore, now it is reduced to 3 lakhs. So therefore, minimum 3 lakhs, specified value, of course, I have repeatedly said it should be a commercial dispute. How that specified value is determined, we will have to go to section 12. I will now take you directly to section 12. Specified value, chapter 3. There is only one section in that entire chapter, section 12. Determination of the specified value. The specified value of the subject matter of the commercial dispute in a suit, appeal, or application shall be determined in the following manner. I repeat, please don't go by the provisions of the Karnataka Court Fees and Suits Valuation Act to determine what the market value is and all that. No. Of course, there is somewhere something, there is a market value here. Let us not go by the meaning given to the market value in the Court Fees Act. Let us read section 12 independently of that. The specified value of the subject matter of the commercial dispute in a suit, appeal, or application shall be determined in the following manner. A. Where the relief sought in a suit or application is for recovery of money, the money sought to be recovered. Obviously, it cannot be less than 3 lakhs. Anything 3 lakhs, anything above 3 lakhs. In the suit or application, inclusive of interest, if any, computed up to the date of filing of the suit or application, as the case may be, shall be taken into account for determining such specified value. It's very simple. B. Where the relief sought in a suit, appeal, or application relates to movable property or a right therein, the market value of the movable property as on the date of filing of the suit, this is important. Appeal or as on the date of the suit, the appeal or application, as the case may be, shall be taken into account for determining such value. Market value in the case of movable property is obviously 1. It is the prevailing market value as on the date of suit. Somebody wants to buy a car, somebody wants to buy some movables. What's the willing price? What is the price that a willing buyer would like to give, and what is the price at which a willing vendor is ready to sell? That is the concept of the market value. C. Where the relief suit in a suit, appeal, or application relates to immovable property or to a right therein, the market value of the immovable property as on the date of filing of the suit, appeal, or application, as the case may be, shall be taken into account for determining the specified value. It is here I want to give some stress. Relief sought in a suit, appeal, or application relates to immovable property or a right therein. It is quite possible for us to be influenced by the provisions of Section 7 of the Karnataka Court Fees and Suits Valuation Act when we think of a market value in respect of an immovable property. Well, I'm not dealing with that. Now, Section 7 of the Karnataka Court Fees and Suits Act. See, there are two things in the Karnataka Court Fees and Suits Valuation Act. Valuation for purposes of payment of court fee and valuation for purposes of pecuniary jurisdiction. Order 7, Rule 1I also would require the plaintiffs to state in the plaint what according to him is the value for purposes of payment of court fee and for purposes of pecuniary jurisdiction. Both need to be stated. It is Section 50 of the Karnataka Court Fees and Suits Valuation Act which deals with valuation for purpose of pecuniary jurisdiction. In respect of valuation for purpose of payment of court fee, there is a separate chapter, different kinds of suits, what's the value. Now, Section 7(2) says, if it is an immovable property assessed to land revenue, and if the land revenue is permanently settled, then it is 25 times the land revenue. It is a deemed market value. It is not actual market value. Nobody can get it. Land revenue would be rupees 5. 25 times would be 125. Because they are poor agriculturists, legislature thought that they should not be burdened with advanced court fee, and therefore they said, or the deemed market value. 7(2)(b) says if it is a land assessed to land revenue and it is not permanently settled, 12.5 times the land revenue. Then 7(2)(c) says if there is no land revenue fixed for that land or the land is exempted, 30 times the land revenue payable for the neighboring land. 7(2)(d), it relates to sites and other house property, commercial complex and other things. There the actual market value. It's a different thing. We can't import that concept or meaning when it relates to the market value of the immovable property here. In the context of section 12(1)(c), the market value is the actual market value. Then D, where the relief sought in the suit, appeal, or application relates to any other intangible right, the market value of the said rights as estimated by the plaintiff shall be taken into account for determining specified value. Those who are familiar with the provisions of the Court Fees Act, section 26C and 24D, would know that the plaintiff is given liberty to make his own valuation in suits covered by 26C and 24D. Something like this. 12(1)(d) says where the leave suit in the appeal application relates to any other intangible right. As for an intangible right, obviously it can only be a notional value. The market value of the said rights as estimated by the plaintiff shall be taken into account for determining specified value. But obviously it cannot be less than rupees 3 lakhs. According to me, it is 3 lakhs. According to some other plaintiff, it is 4 lakhs. It is an intangible thing. I can't value it in terms of money. Then if it is suit and counterclaim, aggregate value of the claim and counterclaim, if any, as set out in the statement of claim and counterclaim in an arbitration of a commercial dispute shall be the basis. Then other things are given. Now, of course, there are some decisions. I'll come to it later. One other section which is of importance is section 8. Notwithstanding contained in any other law for the time being in force, no civil revision application or petition shall be entertained against any interlocutory order of a commercial court, including an order on the issue of jurisdiction, and any such challenge subject to the provisions of section 30 shall be raised only in an appeal against the decree of the commercial court. Those practicing on the criminal side would know that under section 397 CRPC, I am not able to give the corresponding provision in BNSS. There can be no revision against an interlocutory order. Of course, on the criminal side, there are a good number of decisions. What an interlocutory order is, what an intermediary order is. Let us not go into those things. Now, section 8 bars the revision against an interlocutory order. Of course, on the civil side, there is no difficulty in understanding what an interlocutory order is. Now, what then is the remedy? Some interlocutory order is passed, plight is amended, application for recalling, appointment of expert, adding a party. Several interlocutory applications are filed during the pendency of a suit, whether it could be a commercial suit or it could be any other suit. Some of those orders are appealable under section 104 and order 43 CPC. Some of the interlocutory orders, for example, 39 Rule 1 and 2, 38 Rule 5, return of plight, Order 9 Rule 9, Order 9 Rule 13, a big list is given. So if you read section 104 CPC and Order 43, you will know which are those appealable orders. Against a decree, as all of you know, an appeal lies first appeal under section 96 read with Order 41. In respect of interlocutory orders specified in section 104 and Order 43, as we popularly called as a miscellaneous appeal at the level of the senior civil judge and district judge, miscellaneous first appeal to the High Court. But there are certain interlocutory orders, amendment application, impleading, appointment of a commissioner, recalling a witness, production of documents. They are not orders which amount to a decree. They are not appealable orders under section 104 CPC or Order 43. So the earlier 115 CPC revisions used to be filed. after section 115 CPC came to be amended, that revisional jurisdiction is also now restricted, as most of you know, writ petitions are filed. In the Karnataka High Court, it is categorized as GMCPC, the General Miscellaneous CPC. It's a different aspect of the matter. What then is the remedy? Now it says the commercial court ultimately passes a decree. Decree means the suit is decreed or a dismissal is also against that a judgment is preferred. If the plaintiff has lost the commercial suit, he will prefer an appeal. If the suit is decreed, defendant prefers an appeal. Against the decree which is ultimately passed, when an appeal is filed, there could be a challenge to the interlocutory order also. Here, the provisions of section 105, subsection 2 CPC and order 43, rule 1 capital A CPC would be relevant. If you know that, it will be easy for you to understand the scope of section 8. Let me take you to section 105, subsection 2 CPC. Section 104, subsection 1. An appeal shall lie from the following orders and save as otherwise expressly provided in the body of this court by any law for the time being in force from no other orders. A list is given. A to F, A to F, A to D is omitted by some amendment, A to E, F, etc. Then I also told you 43 rule 1. 104 2. No appeal shall lie from any order passed in appeal under this section. That's also not relevant. 105.1. Save as otherwise expressly provided, no appeal shall lie from any order made by a court in the exercise of its original or appellate jurisdiction. But where a decree is appealed from, any error, defect, or irregularity in any order affecting the decision of the case may be set forth as a ground for objection in the appeal. So, then I said subsection 2. Notwithstanding anything contained in subsection 1, where any party agreed by an order of remand, etc. Actually, it is not a 105.2. I stand corrected, it is 105.1. So now, 105.1 says, in the appeal, in the first appeal that is filed, the legality of the order, interlocutory order, against which an appeal does not lie, either under 43, order 43, or under section 104, can also be set forth as a ground of the memorandum of appeal is what section 105.1 says. We have a more or less similar provision in order 43, rule 1A. Rule 1A, subrule 1, order 43, rule 1A, subrule 1. Right to challenge non-appealable orders in appeal against decrees, almost like 104, 105.1. Where an order is made under this code against a party and thereupon any judgment is pronounced against such a party and a decree is drawn up, such party may in an appeal against the decree contend that such order should not have been made and the judgment should not have been pronounced. Therefore, we cannot contend, well, you should have challenged it. No. Appeal is a matter of right, and if it is provided by the statute, one has to exhaust it. Otherwise, the revision is not, we are not bound to file it. GMCPC, we are not bound to file it. We can reserve it and ultimately make that also as a ground in the regular appeal that we file. This is the same thing in your section. Same thing is found in section 8 of the Commercial Codes Act also. Now, I have given you a bird's eye view of the entire enactment. Now, let me refer to a few decisions in this regard. I will come to 12A a little later with regard to mediation before filing the commercial suit. One decision which you may refer is 2015, Volume 5, Karnataka Law Journal 358. I need to refer to a good lot of decisions and therefore I don't give the names of the parties. 2019, 5 KLJ 358. in this decision it is said that twin factors have to be satisfied. One, the dispute must be a commercial dispute as defined in section 21C. It should be of a specified value as determined in section 12. So if the specified value is below 3 lakhs, it need not be transferred even if it's a commercial dispute. Dispute is not commercial, value may be 3 lakhs, it cannot be transferred to a commercial court. So therefore, these steps will have to be followed. Then WP 106016, WP 106016 and 106017 of 2018. WP 106016 and 106017 of 2018 GMCPC connected with WP 109712 of 2016. WP 109712 of 2016. The date of the decision is 3/9/2020. Mahalakshmi Constructions versus Karnataka Neeravari Nigama. Now, it says that matters which were already filed before the establishment of the commercial court need to be transferred. A detailed judgment is. Then we have a division bench decision in 2020. SCC Online Karnataka 218. 2020 SCC Online Karnataka 218. It is commercial application 2 of 2019. Case number is commercial application 2 of 2019. Date of judgment is 23/1/2020. A division bench decision 2020 SCC Online Karnataka 218. Raymond Yuko Denim Private Limited versus Genesis Embroidery. This also for the same proposition that pending suits needs to be transferred. Now, I told you whether a particular dispute is a commercial dispute needs to be examined. Some sections are very clear without any interpretation. We can examine that. But there are certain disputes, whether they are really commercial disputes or not, it is a matter to be examined in great detail, going through the document, client governments, and everything. I am now giving you a few decisions in respect of a few categories where the courts have held that it is a commercial suit and it is not a commercial suit. One of them is the Delhi High Court, CM bracket M. I don't know what this category is. Anyway, CM bracket M 850 of 2016. CM bracket M 850 of 2016, maybe civil miscellaneous or something. Date of judgment 1/9/2016. Of course, in respect of these cases, I will give the parties' names also because they are not reported to citation and other things. Monica Arora versus Neeraj Kohli and others. Neeraj Kohli and others. This was a suit for specific performance. On examination of facts, it was said that the dispute was commercial. Not all specific performance suits will have a flare of a commercial code. No. In this particular case, the dispute, after going through the documents, evidence, and pleadings, the Honorable High Court of Delhi came to the conclusion that a suit for it is on fact. Please don't conclude that all suits for specific performance need to be tried by the commercial court. Then we have a judgment of the Honorable Supreme Court, which most of you may be knowing. It is 2019 SCC Online SC 1311. 2019 SCC Online SC 1311. Ambalal Sarabhai Enterprises. Ambalal Sarabhai Enterprises versus KS Infraspace. Now, let us go to section 2.1. 217. I already read it. In this Act, unless the context otherwise requires, agreements relating to immovable property used exclusively in trade or commerce. Therefore, the subject matter of the suit for specific performance of a contract of sale should be an immovable property, and that immovable property should be exclusively used in trade or commerce. If it is some agricultural land, it cannot be transferred. Even if it is some building or something, it should have been exclusively used. Supposing a portion of it somebody resides it there, or it has been let out, in the other portion he carries on business, that cannot be transferred. This has been made clear by the Supreme Court in this Ambalal Sarabhai Enterprises. It's a decision widely known, and you have read all of it. Now, the next is a decision of the Delhi High Court, FAO, FAO within brackets OS, FAO OS 166 of 2016. Delhi High Court, FAO OS 166 of 2000. Most of these are available on Manupatra. Date of judgment 22/9/2017. 22/9/2017. Names of the parties Jagmohan Behi. Jagmohan Behi versus State Bank of India. This was a case where the bank was a tenant. Bank was a tenant in a premises. A suit for eviction was filed. It was held that the defendant bank, which was the tenant, it was obviously bank was using that premises for its trade and commerce only, and therefore on facts it was held that it was a commercial dispute, and the matter needs to be tried by the commercial court. Then one more decision of the Delhi High Court. This is CS bracket OS. CS bracket OS 23/30 of 2018. 23/30 of 2018. Then connected with 23/31 of 2018. In those suits, number of interlocutory applications were filed. OS 23 CS within brackets OS 23/30 of 2008, connected with 23/31 of 2008. Date of the decision is 19/7/2016. 19/7/2016. Sony Deve versus Trans Asian Industries Expositions. Sony Dev versus Trans Asian Industries Expositions. So this was a suit for ejectment. But I told you, there may be a lease agreement. There may be an arbitration clause also, but the premises is not let out for a purpose which is for a commercial purpose. So on facts, it was found that it was not a commercial dispute. Then suit for recovery of money lent. This is CS 99 of 2020. CS 99 of 2020. It is the Calcutta High Court. Lady Moon Towers Private Limited. Lady Moon Towers Private Limited versus Mahendra Investment Advisors Private Limited. Lady Moon Towers Private Limited versus Mahendra Investment Advisors Private Limited. The date of the order is 13/8/2021. Now, this was a suit for recovery of money. In this case, of course, bank was not the plaintiff in this suit, the private person. Here, that particular provision of the Commercial Courts Act section says ordinary transactions of merchants, bankers, financial institutions. That has also been referred to. Here, in this case, the plaintiff was not a regular money lender. His business was not money lending. Because there was some familiarity between the directors of the party, directors of the company and plaintiff, loan came to be advanced. What is important here is the Honorable High Court of Calcutta has said this assumes importance in the difference recognized under Section 34 CP. From day one, this has been my view also, of course, whatever be my view, ultimately I'll go down to the decision of our High Court or the Supreme Court as and when we get a direct decision. The reason is this. If we simply go by the those words, commercial dispute, ordinary transactions of merchants, bankers, financiers, and traders, such as those related to mercantile documents, including enforcement and interpretation of such documents. So, mercantile documents, what are those? All these things have been explained in this decision. Why am of the view that all bank suits do not get transferred to the commercial court or not triable by the commercial court is this. Now, banks lend loan for growing crops, for purchase of livestock, house loans, educational loans. If a loan is lent for purchasing a house for a person to live, or for buying a site, or for medical expenses, or educational loan, as crop loan for purchase of livestock, can it be by any stretch of imagination be said to be a commercial dispute? There is one more reason for this. As per Section 34, one thing I want to tell you, Section 34 CPC is not amended by the Commercial Courts Act. What the Commercial Courts Act schedule says, if there is a claim regarding interest, what is the interest that is claimed? Is it pendent, allied, or future? Everything has to be clearly stated. That's all. Section 34 aspect is not amended. Now, if we simply go by the first part of the definition saying ordinary transactions of merchants, bankers, bank has lent money for an agricultural purpose, educational purposes, house loan, and everything has lent. Now, thinking that it is a commercial dispute by going by the definition, it is tried by the commercial court or transferred to the commercial court, or the plaintiff is returned for presentation to the commercial court. Now, when it comes to further interest under Section 34 CPC, what's the consequence? Some of you at least may be knowing that Section 34 CPC contemplates interest for 3 periods. Prior to the suit, interest from the date of suit till the date of decree, that is called pendent allied interest. Then interest from the date of decree till the date of prepayment, that is called further interest. Language used in 34 CPC is further interest, but sometimes we call it as also future interest. Now that interest from the date of suit till the date of decree, pendent allied interest, a reading of Section 34 would show it is the discretion of the court, what the court finds reasonable. As far as further interest, that is from the date of decree till the date of payment, there is a ceiling. It cannot exceed 6% per annum. But there is a proviso attached to Section 34 says, if the liability of the dependent has arisen out of a commercial transaction within the meaning of then that interest might exceed that which interest, further interest from the date of decree can exceed 6%, but not the contractual rate. If there is no contractual rate, bad rate, and everything. Now, a suit merely because it is filed by a bank is transferred to commercial court or entertained by the commercial court. So, entertain the suit, it becomes a commercial dispute. But when it comes to award of further interest from the date of decree, we will have to go by Section 34 CPC, then say it is not a commercial transaction. We will have to limit the further interest only to 6%. This appears to me to be a little incongruous. Anyway, view is divided in this regard. Some hold the view that all suits filed by banks are triable by the commercial courts. I hold the other view, and this decision gives some indication to that effect. Anyway, please don't go by what I have said. You examine in a given case. If by chance we get some decision of our High Court or the Supreme Court, well, whatever I have said. Then, contrary to what I have said and contrary to what the Calcutta High Court has said, we have a decision of the Delhi High Court, 2023 SCC Online Delhi 7374. 2023 SCC Online Delhi 7374. Sushil Sharma versus State Bank of India. Sushil Sharma versus State Bank of India. In this case, the Delhi High Court has said that even home loan would qualify itself to be a commercial dispute, and that has to be tried by the commercial court. So, as I said, it all depends upon how the court use it, how the lawyers would make their presentation, and as on the date you argue what are the different views the courts have taken. I have just given only my view. Don't say that my view is the correct one. You are free to have your own view about it. Then, as to how the specified value needs to be determined, we have a decision of the Karnataka High Court. It is directed to be reported. I am not getting the citation. I will give you the date of judgment and other details. It is CRP 426 of 2023. CRP 426 of 2023 within brackets IPR, that is intangible rights. 426 of 2023. Date of judgment 7/6/2024. CRP 426 of 2023 within brackets IPR. Date of judgment 7/6/2024. Messrs. BTV Kannada Private Limited. BTV Kannada Private Limited versus Edelsight Media Private Limited. Edelsight Media Private Limited. A detailed discussion is made in this regard about the provisions of the Court Fees Act, about Section 12 of the Commercial Codes Act, how specified value needs to be determined in that case. Now, the last aspect which I want to cover is about 12A, found in Chapter 3A, which came to be inserted by the amendment brought into force by Act number 28 of 2018, which came into force on 3/5/2018. 12 capital A. Pre-institution mediation and settlement. A suit which does not contemplate any urgent interim relief under this Act. Please mark those words. Interim relief under this Act shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation in accordance with such manner and procedure as may be prescribed by the rules made by the central government. Subsection 2. The central government may by notification authorize the authorities constituted under the Legal Services Authorities Act for the purpose of pre-institution mediation. Of course, we have these mediation rules and other things. My own knowledge of that mediation procedure or mediation rules is limited. It's not my cup of tea at all. I don't want to venture into it. But as far as Section 12A is concerned, a suit which does not contemplate any urgent interim relief under this Act. What are the applications that are filed in these suits to give, without exhausting this pre-institution mediation procedure? Urgent relief, 38 Rule 5, attachment before judgment, 39 Rule 1 and 2, temporary injunction. Are the urgent reliefs contemplated under this Act? No. They are contemplated under Civil Procedure Code. Throughout this enactment, from sections commencing from Section 1, ending with Section 23, there is absolutely no urgent relief contemplated under the Act. We are yet to get a pronouncement on this. In fact, in a recent judgment, in 2022 judgment of the Supreme Court, about which I am now making a reference also, the Supreme Court has said we are not pronouncing on the question, what is this urgent interim relief? They have left it there because maybe in that case it did not arise. According to me, since the reliefs which are usually sought as urgent reliefs, 38 Rule 5, attachment before judgment, arrest before judgment, 38 Rule 1, then temporary injunction. They are not urgent reliefs under the Act. No urgent relief is contemplated by this Act. So if we strictly go give a literal interpretation section 12A, every suit will have to undergo the process of pre-institution mediation. That is one aspect of the matter. Now we have two judgments of the Supreme Court, which some of you may be knowing. One is in this Messrs. Patil Automation Private Limited. Messrs. Patil Automation Private Limited versus Rakheja Engineers Private Limited. Rakheja Engineers Private Limited. Arise SLP 14697 of 2021. 14697 of 2021. The date of judgment is 17/8/2022. 17/8/2022. This decision is directed to be reported. I am not getting the citation. Of course, lawyers practice in the commercial courts know this. Now, a detailed discussion is made about Section 12A. Ultimately, the Honorable Supreme Court has held that 12A is mandatory. If the pre-institution mediation process is not undergone, plaint is liable to be rejected under Order 7, Rule 11. Of course, Order 7, Rule 13 provides if a plaint is rejected under Order 7, Rule 11, plaintiff is not precluded from bringing a fresh suit in respect of the same cause of action. Well, he has to undergo that mediation process. But what he stated here is, for whatever reason it be, some suits were instituted without undergoing this 12A process. The judgment of the Supreme Court is 17/8/2022. The Honorable Supreme Court said, if a suit is instituted prior to 28/2022, see the judgment is dated 17/8, some 3 days marking is given. If the suit is filed on or after 28/2022, 12A necessarily needs to be complied with. Otherwise, the plaintiff is liable to be rejected. If a suit is already filed prior to 28/2022, because law is not clear, this these mediation the centers and other things were not established for this pre-institution mediation and all that. So therefore, taking all those things into consideration, the Honorable Supreme Court said, if a suit was already instituted prior to 28/2022, plaint shall not be rejected. But subsequent to that, the plaint needs to be rejected in the mandatory nature of Section 12B. Almost to the same effect is the subsequent judgment. It actually has actually followed it in Messrs. Dhanbad Fuels Private Limited. Messrs. Dhanbad Fuels Private Limited versus Union of India. Civil Appeal 6846 of 2025. Civil Appeal 6846 of 2025. SLP 4980 of 2021. SLP 4980 of 2021. A very recent judgment, just only 4 days old, 15/5/2025. It has followed the judgment in Patil Automation Private Limited. Of course, if you read this Patil Automation Private Limited, apart from Section 12A of the Commercial Courts Act, you will get a bird's eye view of the entire provisions of the Civil Procedure Code and the Commercial Courts Act is what is a suit, how it is instituted, all those details you will get it. So ultimately, And this the subsequent judgment, both of them have been directed to be reported. I don't have the what's those citations. Please go through them. A very long judgment, detailed discussion has been made in these judgments, and it has been held. The suit is already filed prior to 28 2022. No need to reject the claim, otherwise claim needs to be rejected. In both these decisions, what is that urgent relief, urgent interim relief has not been considered because it did not arise for consideration in most cases. This is all what I wanted to tell you. And of course, two more decisions I just want to bring to your notice. Well, that may not be necessary now because, uh, as I said, I have not dealt with the scheduled portion of the Commercial Courts Act dealing with amendments to CPC. So that will be relevant there, not now. I will leave them for the present. Uh, well, as far as I am concerned, I have completed what I intended to complete. If there are any questions, welcome.
I repeat, if there are any questions, you may send those questions in the Q&A box, or you may hit the hand raise button. So I'll unmute you and you may pose the question directly to our speaker. Just wait for a few seconds, sir.
Whatever.
Somebody has any question? Just wait for a few seconds. I repeat, if anybody has any questions, they may post those questions in the Q&A box. So I'll be reading it on behalf of you, and sir will be addressing those questions. Or you may parallelly also hit the hand raise button so I can unmute you and you may directly pose the question to the speaker. Maybe we would conclude that, sir, in your erudite style, you have always not given any scope for confusions, ambiguity. And in that earnest, perhaps we have no questions today.
Or they might have come to a conclusion that I may not be able to answer their questions also. Both the things are possible. All right.
I would go with my option.
Anyway, thank you, Mr. Trivikram.
Sir, we are so thankful to you, sir. Every time you have been accommodating us.
Yes. So, as I said.
And I think we have one question, sir.
Yes, please.
What was the date from which section 12A was made compulsory?
Yes,
Perhaps.
I give it. Andre, as per the judgment 28 2022, but 12A came to be inserted by an amendment of the year 2018. I give the exact date right now. That Act 28 of 2000, it came into force on 3/5/2018. 1 minute, yes. It came into force on 3/5/2018. But there is some confusion because if you read the second judgment which I gave, Dhanbad Fuels Private Limited, there were some places where no proper infrastructure was there for going through this pre-institution mediation. There are so many practical problems. Taking all those things into consideration, the Supreme Court in both the judgments said we shall give effect to it from 28 2022. The date of the first judgment is 17, some 3 days margin, because people also should get to know what the judgment is. It is in that context. Something like that Surat lamp case where it was held. If some sales have taken place on the basis of GPA, let us not disturb them. In future, there can be no sale by GPAs and other things. So similarly, they said in future, but the amendment as such came into force on 3/5/2018 by Act number 28 of 2018. Yes, any other question?
Yes, sir. I think that's it for today, sir. So once again, sir, many thanks on my personal behalf and on behalf of Advocates Academy, Bengaluru.
Now, as far as amendments brought to the Civil Procedure Code by the Commercial Codes Act, unless the participants have also with them the Civil Procedure Code, it will be difficult. Whether I speak or somebody else speaks, it will be very difficult because so many provisions are amended. It requires a good and it requires a detailed discussion. So many, there is nothing to interpret, but so many provisions, subrules, subsections, and all that. Therefore, we should have with us the civil procedure code also, and the time is too insufficient for me to cover that also. Therefore, I have not covered it. I have only covered the section portion of the commercial codes act. Only those sections, other things which are not of much consequence, I have not covered.
We would definitely have second sessions, sir, covering those amendments so that our participants will take benefit of the same.
Maybe post vacation.
Post vacations, yes. Hardly have about a week or more in the present vacation, summer vacation.
Yes.
1 or 2 webinars we would be winding up. Post vacation, we'll definitely take up these topics.
As per your schedule, it is on every Monday and Thursday.
Yes, sir.
This week you will have only 22nd Thursday, and next week 26th Monday and 29th Thursday.
29th Thursday. And
Before
for a change, we will be having on 30th instead of
so
29th.
therefore, you will have only 3 more sessions prior to this
Conclusion of the vacation.
That is one on 22nd, another on 26th, third on 30th.
Yes.
So rest of it we can have it about this.
It has been a routine that we have been having every Monday slots booked for you.
Yes,
you have been so kind to share your knowledge with all of us.
All right. 26th, you have suggested some subject. I'll be there on 26th.
Yes, sir.
Rest only after vacation.
Yes.
And as I said, preferably on the civil side.
Definitely. Yes, sir. Thank you so much.
Okay, good night.